Okay. Okay, just, we're gonna do this one. Did Mr. Hamadou submit to the 1077?
No, Your Honor.
No, I didn't, Your Honor. I sent you a letter exercising my Fifth Amendment right. You brought in, prosecuting attorney brought in somebody to testify that I'm committing insurance fraud, and then you accused me of terrorism, and so I'm gonna remain silent.
Okay, I don't recall ever accusing you of terrorism.
Well, you referenced my Facebook, Your Honor. You referenced my Facebook, one of the first hearings that we had, and you mentioned that I could be subjected to 12 years in prison, if you recall, for terrorism. And so
I'm pretty sure those words did not come out of my mouth. 'Cause I don't know anything about 12 years
there was a
for terrorism. I would indicate you have sent numerous letters. I don't lost track, 4 or 5. I've given those to the prosecutor and to your attorney, and you've asked me questions such as how much stock do I own in Bowflex? Wanted me to
I've asked you
respond to your questions.
direct questions.
Yeah, you did, about how much stock I have in Bowflex. As far as I know, I have none. I mean, there may be state retirements that have some kind of annuities or mutual funds or something like that. You've also asked me how much of the jail I own and how you want to know the percentage of the jail that other judges own. You remember asking me those things?
Yes, I do.
Okay, well, we own as much of the jail as you do.
Okay,
I mean,
good.
it's owned by the public, I guess. And you've asked me why your wife's attorney has pictures of her on the cell phone, and
No, my attorney, I've asked for discovery of.
no, you've asked me why your divorce attorney has pictures of your wife on his phone. I have no idea if he does. I presume he probably doesn't, because you've also indicated in your letters that you think that same attorney is poisoning your dad to get his $2 billion. Do you remember telling me that?
I put that in the letter, yes.
Your dad has $2 billion.
No, I didn't say that.
You did, but okay.
Okay. He was offered that for his company.
He was offered $2 billion? Maybe 2 million, but I doubt it's 2 billion, but I don't know.
Okay, that's what I
So,
was told.
I know, but you understand, you're telling me that you think the same attorney is trying to poison your father, correct?
I believe, I don't know.
You
I
wrote
would
that-
like it investigated, Your Honor. That's what I would like investigated. yes.
Okay. And then you've continually told me that I'm in cahoots or something with some officer. To the best of my knowledge, I don't even know. That's this officer who you think is out to kill you, correct?
Yes.
You use the word render, that the officer's out.
He attempted
To render
ran
you.
me off a cliff, and then he's made a few, I believe he's made a few other attempts on my life, and I filed a lawsuit against Clark County in regard to that was just recently dismissed by Judge Matthews.
Okay, so you sued the officer who you say is attempting to kill you.
I sued Clark County.
Okay, well, him in Clark County, and he said that's been dismissed. Okay. It's unfortunate this thing's been dragging on so long. Part of it, again, is because it's alleged you made threats to cause harm to your other attorneys, so they had to close down their office, withdraw from the case, and you had a new attorney. And in your letters, you've asked me to, I think, dismiss, but I'm not sure, because you go back and forth in your letters, dismiss this attorney, and that you want to represent yourself.
The original hearing, if I may,
Go ahead.
you said that I needed to be evaluated to see if I could represent myself.
You have that right. That is correct. That's
And
something I did say.
I acquiesced and said, no, I cannot represent myself. I'm not in a position where I can represent myself. And I've
Oh,
asked-
okay, but you did say you wanted to represent yourself, and I said, well, first I'd have to determine if you were competent before you could
to
represent yourself, because I
myself, yes.
understand you may have funds, because in your letters or in your prior conversations, you've said how you've spent, $20,000 on divorce attorneys over the last
On a criminal defense
year or
attorney.
two. Well, you said on, I think, dissolution or divorce attorneys. But I said, even if you have funds, you know, and you're not gonna use those funds to hire an attorney, I'd have to have you determined to be competent or whatever before I could let you represent yourself. Okay, so that's kind of where we're at. What new do you wanna tell me now?
Well, I am confused as to, and I filed a motion to dismiss, based on, a couple of things. And the first one is I was exonerated of the charge I was exonerated of the charge on February 17th. So I don't understand why they used the same recharging document and filed a different charge. So I think that's against the double jeopardy in the Fifth Amendment.
Was he initially arrested on a felony?
Yes, Your Honor.
I'm sorry, I didn't hear what you asked.
My question was, again, this case precedes me coming on board. It's quite common, and it's, I guess, assume it'd be to your advantage. Most people, if arrested on a felony, would prefer they not be charged with a felony. So after further review, they decided to not bring it forward as a felony where you could get, you know, up to whatever, 5 or 10 years in prison, and to charge it down here in district court.
Okay.
So it's only double jeopardy once you went to trial. You've been at
Well, this is a
trial on
complete
something.
acquittal, isn't it, Your Honor? That's where I'm confused, I guess.
No, it's just, it's a dismissal. It's a dismissal on your felony charges, and
Okay.
they file them down here in district court instead.
Okay, so they came down and they filed it on the probable cause. And I want to read the probable cause statement, if I could, because this has never been signed by anybody. Is that okay if I read this into the court?
It would be a court record. For what purpose?
Well, I mean, this is rife with errors. The probable cause statement says, Sergeant Torres, Deputy Schmidt, and I responded to 95 17th Northeast Hazeldale. Sergeant Torres, Deputy Schmidt, and I responded. And on the bottom of the signature, it's signed by Deputy Schmidt. Okay, so that's the first problem in the probable cause. And then it goes on to say that I will kill you. He's been taught to kill, and he stated he would kill her. I never made any of these statements, Your Honor.
Okay, well, those are issues to be determined at trial.
Right, and they've hidden the
I think it made
witness.
reference that you, on a number of occasions in your letters or comments in court, have said you were a Navy SEAL. Maybe that's where they got this part about you're trained in combat.
Right,
But your
and-
wife said that's not true. That's a delusion on your part,
And so
is what your wife said.
She came in and testified that I was never a Navy SEAL. But in this probable cause statement, she says he's had military training as a Navy SEAL. So she contradicts herself right there. And she hasn't been able to be questioned for 22 months now, even before the psychological evaluation.
Okay, those are issues that you can take up at trial if it's true that somebody gave what was called an inconsistent statement to
Okay.
an officer.
And I think you have enough information to dismiss this based on your witness. Your fact witness is not credible. She's on opiates. I have an affidavit
Okay.
filed in court saying that I've
Okay,
been
well,
on
before we get to the trial procedure, you know, you need to, is there a motion from the
Your Honor,
prosecutor here?
Mr. Lamadou did not submit to the 1077 as
This guy's
required by
gotta be
the
in
court.
20
We
minutes.
received notice from Western State Hospital.
Has he been charged yet?
Here, we're asking that he be taken into custody and that the 1077 evaluation occur at the jail.
Your Honor, the order says that the order said it would be within 21 days of assigning counsel. When you assigned counsel to me, you assigned a counsel that had a conflict of interest. You assigned Katie Kaufman as my counsel that worked for Jeff Barrar, and that was a law firm that sued me for 10 years. And when I brought that up and I started asking for the files from the Jeff Barrar law firm to go back to see if he was conflicted out, he made up a story about me threatening him. Now, if he feels threatened by me asking for discovery to see if we have a conflict of interest, there's probably a conflict of
Okay,
interest.
well, I don't know all I know is what little I heard, and I'll put on the record what I heard. That
Okay.
you allegedly made threats to somebody in their office, they had to close down their office, call the police, and then they got out of the case. There's nothing that I'm aware of, and it would be in the court file, that they had to withdraw because they had sued you before. Mr. Barra is here, I don't think he wants to speak, but anyway, so I know nothing about them suing you for the last 10 years unless Mr. Barra.
Well, he was
Doesn't
partner
know
with
something
Dennis
about that.
Lane. So Dennis Lane was the guy that sued me for 10 years. And
I don't,
so there was obviously a conflict, and he used that conflict to make up a story about me threatening him.
okay, that's your version, I guess.
Yeah, and so
The other-
what do
just
we
a
do
second,
about
just a
that,
minute, the
Your
other-
Honor? What do we do about that?
But
Is
we're
that
past that. You now have a new attorney. They no longer represent you if you think they're, again, I'm not saying there was a conflict. I don't know anything about
Do AGM.
the Lane Marshall law firm. Is that what you're talking about?
Yes, English Lane, Marshall, and
And
Vanderwood, and it used to be.
Well, I inquire, what year did they sue you?
Started in 2003, and it went through 2010.
I know Mr. Barra has been away from that law firm for a number of years. I don't know how many, but maybe
Okay,
10 or more.
and so I asked him for the files to see if we had a
Okay,
conflict.
well, anyway,
and he
that's
didn't
another
say
issue.
that.
What, the other, that charge has been filed?
Yes.
And
And a judge, just a second, a judge determined, I guess, probable cause, set conditions of release? It's in Superior Court or where?
I think they sent it by summons because of the time lapse, and so he has a court date on November 29th. So they haven't sent conditions yet.
In Superior Court?
Yes.
Okay, so you understand you've been charged,
No, no.
you've been charged, you've also been charged with a felony offense in Superior Court then? Okay, so, again, your motion is?
My motion is for Mr. Longley to be taken into custody, submit to the 1077, and hit the jail.
And Your Honor, in the
And
The
bail
second,
is set.
and his bail now is,
Right now, he's out on just release.
do you have anything to say?
I don't really have much to say on this. I set an appointment up at my office for him, and
9 o'clock, yeah.
his intention is clear. He's not going to take the evaluation. I would counsel him that talk about the facts of this case,
Is
the
she there?
1077 evaluation, and I'd ask him if that makes it.
But that's why I'm running around here. I know she's.
I don't. Are you going to take the evaluation?
well, I told him that I would there on the order it says a mutually agreeable place and time, and I asked for him to subpoena witnesses to be there with me, and I asked for Congressman Ryan Zinke, who used to be stationed with me at SEAL Team 1.
Okay, well, Congressman is gonna show up
I
at a
asked-
medical type
Okay,
interview.
and I asked for
okay?
Admiral William McCraven to show up, and Dr. Kevin Walters, all former SEALs, to be subpoenaed there as well. So, because I think it's not appropriate,
Be a
Your Honor.
Present, you want that, I mean, maybe they're relevant for the trial, but they won't show up and they wouldn't be part of this,
And I asked for
interview
a
by Western State
specific-
Hospital. Okay,
Okay.
you've told me, you've told your attorney you won't submit, you've written letters to me saying you're gonna exercise your Fifth Amendment rights, you had a chance to be interviewed by Western State Hospital out of custody, you refused to do that, so now I want you to cooperate, it's gonna be much better for you. The officers are gonna take you into custody.
Okay.
If you do submit, I mean, once this is over, my intent again would probably be to release you. But it's gonna be, I can't just let you come up with all these reasons to postpone it. It would take another month or so, or 2 months now, if we did it out of custody, because that's just how it happens, where they now, I think, interview you within 7 days or something rather quickly. So you're gonna go into custody to be evaluated, and we'll need to figure out a time. And as soon as you submit to that evaluation, understand, you can even have your attorney, you can request that your attorney be there, and they're just gonna talk to you, make sure you understand the nature of the proceedings, that you're able to assist in your defense. Those are the questions basically that they cover.
I don't, he has done nothing to help me at all, hasn't been investigating any witnesses, hasn't even interviewed my wife, who hasn't been interviewed for 24 months. And
Okay.
And you understand that.
If
You
you're found
understand my
incompetent, the charge maybe be dismissed. So I guess, I don't know why,
Well,
or what he's doing, but,
so I can't, I have another
Okay.
charge pending against me, and I have to sit here and I need to talk to somebody, and I can't remain silent.
You can remain silent. You have the right to remain silent. You can remain silent. You don't have to talk about the facts of this case. Generally speaking, in these 1077 evaluations, they're going to talk to you about things other than this case.
and I guess someone will notify Superior Court, maybe they'll move them up or whatever they'll do.
Probably, Your Honor.
What was
Also,
the
what date
charge in
should
Superior
we-
Court?
What date works for you, Mr.?
Return?
It's usually 2 weeks, so do you wanna do 20 or?
Making death threats, apparently,
Well,
because it's felony harassment.
Let's do the 28th.
That was the charge in Superior Court?
All I have is this little note that says was charged, and to be felony harassment, has to have some sort of death threat involved.
Against who?
I'd
The
advise
Barra
you not
Law
to talk
Firm or
about-
somebody connected with one of your prior attorneys, I believe.
Just, no, I have court, Portland, but, I'm okay doing it next month.
There's no bail?
You don't have an order ready?
No bail.
I guess I did. You saw my notes.
They can note it on sooner. I mean, if they can
I can text
evaluate you in the next couple of days, we'll do a hearing after the evaluation's over, and I'll set some conditions. Or release you. Again, I just want you to cooperate now, obviously. Be the gentleman that you seemingly have always been in court. Okay? I'm really encouraging you to cooperate and whatever. They prescribe medication. I think things are gonna work out well for you, whatever they do. And we have more of an understanding of conversation, and you can understand what's going on better, okay?
Okay.
Thank you.
Your Honor.
Can I drop these off?
I'll take them. You're gonna go over there and use
My
that.
ID, can I give that to my
Yeah,
friends?
go on over there and sign, so we can deal with it.
Kevin Nelson?
Who's supposed to be?
Mr. Nelson's in custody on,
Just a minute, they're not gonna let him walk over for a minute.
well, it's just gonna be a set over.
Oh,
track
okay.
with the pending felony. He was arrested on,
Okay, how far out?
at least a month. I'm not sure what the court schedule is, but.
What's his pending felony?
It's a felony no contact order violation. He's
What does
just-
he have here? You said he has a felony no contact order violation. What does he have here?
Probation
Oh,
violation.
it's just,
tracking
I see, a
law
PV,
violation.
thank you. He does, obviously, he doesn't wanna take care of this first, he wants to wait.
I asked folks to email to Nancy, so.
Come back mid to late December, if not early January on the DUR docket.
Sorry, man.
It's okay.
Say December, let's do December 15th in the afternoon. Just over the computer, you're gonna sign for somebody. Gonna do Tamara Spear?
Wow.
Your Honor, Ms. Spears here on a readiness hearing to execute a waiver of speedy trial and set this matter over. Looks like she just needs to complete an anger evaluation. Prosecutor and I are very close to negotiating that.
Trying to get judge to let me do a 1077 here.
That's agreeable with the state?
Correct, Your Honor. We'd ask that
Whatever it is.
we strike the trial.
Looks like this is why you could do that.
The resolution down there.
We could waive as of December 1st on this one. That would allow us to set it over to January, we could do January 10th. Actually, January 9th.
Henry, just step in the hallway.
They want it over till Monday, January 9th, is that
Yes,
correct?
please.
Okay. Ma'am, you'll come back at 8:30 in a second. After that gentleman leaves, you'll step over to the computer screen and sign a document. You can maybe sign that before I'm gonna check.
Just setting it further.
Christopher? Here, I have Christopher Vernacki here, V-E-R, last name for readiness. It's gonna be dismissal, is my understanding.
It's correct, Your Honor. This is a,
Okay.
excuse me. This is an assault 4 allegation. Between, looks like they were married. This was an apprehension of fear assault 4 allegation, Your Honor. No known criminal history. We had an opportunity to speak with the victim. There was no Smith. In our speaking with him, he indicated he wasn't fearful. don't believe that we had any substantive evidence at this time, Your Honor, so.
Okay.
In position to discuss the case.
No contact order's already been lifted, or wasn't issued.
It looks like it was
Okay.
not based on.
That's fine. Nothing to drop then.
Nope.
Nothing to.
Okay, your charge, as I've indicated before, it's highly unlikely. I'm not sure if it's ever been done, to be honest with you, that they refile. I said it's highly unlikely they'd ever bring these charges forward, but again, if, you know, in an extreme case where there was another incident and he said, well, yeah, he did it this time too, and, you know, whatever, they could bring it back. So obviously, the best thing to do is not get in any trouble and make sure the statute of limitations have ran by that period of time. But in other words, they could refile. But like I said, I've never seen it done, but that doesn't mean it couldn't be done. That's what a dismissal without prejudice means. Understand that? Okay, thank you.
Thank you, Your Honor. Mr. Rivera has the next three cases.
Thank you, counsel. Andre Regueza?
Okay, wait a second, what did we just
Yeah.
do with that guy?
Sorry, dismissal without prejudice. Just, I'm gonna pause.
Was there
No contact.
My cheaters, my glasses I left. What year did you leave the Marshall?
2006.
It's been 10 years. I didn't even know who, I heard that name, but I'm not sure I ever met him, or seen him,
Yeah,
who Mr. Lane is.
Rather not comment.
Yeah, I
on
understand.
the record on the case.
Yeah, I know, I don't know.
That way you don't have
This is Mr. Regueza, Your Honor. When the court's ready, we have